Welcome back to another episode of Immigration Law for Tech Startups. I'm Anita Koumriqian, filling in this week for Sophie Alcorn. I'm a family immigration law expert and a partner at Alcorn Immigration Law, the fastest growing immigration law firm in the Silicon Valley. At Alcorn, we work with founders, professionals, and families from around the globe, as well as rapidly scaling tech companies. In today's episode, I am thrilled to be joined by Lydia Hsu and Kara Foster, the founding partners of family law firm Foster Hsu LLP. Lydia and Kara's law firm handles all aspects of family law matters such as prenuptial and postnuptial agreements, divorce, and domestic violence issues. Welcome, Lydia and Kara. Thank you both so much for joining me. Before we get to chatting, let me give all of our listeners a bit of an intro or just some more information about the two of you. So Lydia and Kara co-founded Foster Hsu LLP in 2019. They have experience in all aspects of family law matters, including prenuptial agreements, postnuptial agreements, domestic violence issues, child custody and visitation, child and spousal support, property identification, characterization, and valuation, as well as division, reimbursement claims, guardianship, and step-parent adoption. So basically everything under the moon family law related. Lydia and Kara serve as volunteer settlement officers for the family court, which is fantastic and awesome of them. Before co-founding Foster Hsu LLP, Lydia and Kara were both colleagues and senior associate attorneys at the largest law firm in Northern California. Currently, their clientele includes C-level executive, business owners, engineers, startups, employees, other attorneys, medical professionals, and stay-at-home parents. Lydia received her law degree at the University of San Francisco School of Law. She speaks Mandarin Chinese. Kara received her law degree from the Santa Clara University School of Law. That's where I went, so I really should have gotten that name correctly. Kara earned her bachelor's degree in biochemistry and cell biology and psychology from UC San Diego and worked in biotech and pharmaceutical industries while attending school, which is so rare and awesome. Thank you again both so much for joining me today.
Thank you for having us.
Of course.
Yeah, thank you.
So let's dive in. We have a list of questions that I want to ask you guys. So primarily the reason that I wanted you to join us today me on the podcast today was because family law comes up a lot in immigration, especially family-based immigration. I have no idea how many times at this point that I have reached out to the both of you or either of you to send a potential client or a client your way. So first of all, thank you so much for always taking care of my clients. But it comes up a lot. And we work hand in hand with one another. So let's just go ahead and dive into my questions. So why don't you tell us a little bit more about how you met and what prompted you to start your own practice?
So Kara and I met back in 2013 when we started working together at a large family law firm. And it was one of those friendships that right from the beginning, we got along personally and also important professionally as well. We both have very similar work ethic and we both have very similar philosophies of how we want to practice. So our goal for our clients is to really get them through a difficult situation and educate them as to their options and guide them to the possible best result that they could have, while also working together to make sure that in the end, they're going to be okay and that they know they're going to be okay. We both from very early on had a desire or a drive to start our own practice. And in just organic discussions, it was brought up and we decided to team up and to see where things went. We actually decided to start a firm together back in 2014 or 15. And it just took us a little bit of time to continue to get experience, which is invaluable to our clients. And then ultimately timing, it worked out to leave in 2019. And it's a decision that we will never look back on.
That's awesome. It's always scary to jump ship from a larger practice and to start your own. For all of you that are listening, Lydia, Karen, and I, we met at an organization called Provisors, which is a professional networking organization. And it has, I think for all of us across the board, just kind of helped boost our network, and just the people that we're able to connect with and connect our clients with, which has been so much fun. We several times a week wake up bright-eyed and bushy-tailed at a 7 a.m. meeting to network with a whole host of professionals, and it's a lot of fun. But I'm sure that's helped a lot as well. You guys are both rock stars in your groups, and we love that. I love that. So what I refer to the both of you guys, the reason that I refer my clients most are for prenups and for post-nups, prenuptial agreements and post-nuptial agreements. What are they, and what is the difference?
So a prenuptial agreement is something that people who are not married are eligible for, essentially. It's going to be a contract between two people who are going to get married. And it doesn't actually go into effect unless and until they actually do get married. You can, in a prenup, go over and make agreements about all sorts of different issues. The most common ones are regarding property and assets and how they want to characterize them. So for California, it's community property state. And with that, once you get married, everything that you start acquiring during the marriage becomes community property. In a prenup, you can say, I don't want this to be community property. I want it to remain my separate property. You guys can make those, or individuals getting married, they can make those agreements and they can keep everything separate, or they can parse out what they want to be community, what they want to be separate. Which has come up a lot more in recent years because people are getting married later, and they have assets going into marriage, right? People have houses that absolutely complicate things. They have businesses that absolutely complicate things. They have 401ks that they want to keep and make sure that it's theirs. So properties stuff is something they can deal with in a prenup. You can also talk about and make agreements about spousal support. Spousal support is a hugely contested issue in divorce because it is not as black and white as a lot of things, right? It's very subjective. So a lot of people, when they, see their parents going through divorce growing up, a lot of it's not really about property division so much as spousal support.
Interesting.
Also, otherwise known as alimony. They don't call it alimony anymore in the courts, but a lot of people still call it alimony. So you can waive spousal support in a prenup. You can limit it. You can set sunset clauses to where, if you're married for 20 years, then it's going to go away. Sorry, spell out. Or whatever agreements you guys think or the parties think is fair. You can protect or waive rights and obligations that come up when you become married, right? People don't really think about it as a contract, but when you get married, that's a contract. It's a legally binding contract. And there are certain things that the California legislature has said, this is what you're responsible for when you get married, right? And a lot of people don't know that or understand that. We are also huge advocates of people talking to a family law attorney before they get married so that they just understand all of this, right? A prenup might not be right for you or anyone else, but at least they should be educated going into a marriage and know what they're going to be responsible for, what their obligations are going to be, and how California is going to treat their property and their assets and their income during the marriage. A lot of people just don't know. And we have a lot of people coming in later for a divorce saying, man, if I knew this, I would have done everything differently.
Oh.
So huge advocates for that. Go talk to someone, even if you don't want a prenup, but understand. Other things that you can do in a prenup, though, you can protect things for children of former marriage or prior relationship. And one of the other really great things that I like about prenups is that it forces people to talk about the hard issues. It forces people to talk about how they're going to deal with their income during the marriage, how they're going to deal with any debt they have. And it forces them to disclose everything too. You have to fully disclose when you do a prenup what your assets are, what your debts are, and this is what your income is. This is a lot of things that people may not actually talk about before they get married. All in love and happy, and it's just not something that they think about, but it's hugely important in a marriage. So prenups, I like to say, are roadmaps for how your marriage is going to go. And it forces people to talk about that stuff before they actually get married.
Yeah, we do a lot of divorces caused by financial issues. And that's where sometimes a postnup is helpful. A postnup is similar to a prenup, but it's between married couples. So sometimes people come in and their relationship is great, except the only thing they're fighting about is financial stuff. How he or she spends money is not agreeable to me. How he or she, maintains or how they're running the rental property is not agreeable to me. Things like that. So having a prenup can avoid all of those potential discord during the marriage. If the parties are already married, we can do a post-nuptial agreement, which is very similar to a prenup. We can talk about how property is characterized, what's mine is mine, what's yours is yours, this is separate property, this is community property. But one of the things that you cannot do in a postnup that you can in a prenup is limit or waive spousal support. Once you're married, the court doesn't allow you to limit or waive spousal support. There's actually case law that says that that is not enforceable. So whenever possible, we do try to get couples to do prenups rather than postnups because there's just a little bit more power in a prenup.
Very interesting. So finances come up a lot in marriage-based green card applications. What the USCIS officers or just the US government is looking for in the foundation of a relationship is has this couple weaved together, commingled their financial assets? Because in the US government's or USCIS's eyes, if a couple has weaved together their assets or their financial obligations, they're less likely to get a divorce. It's more often than not is a good faith relationship. So finances come up a lot, and that's where prenups come in too, right? Especially for us when I'm speaking with clients and they're not married just yet, or they just got married, and I ask them, so a huge way to prove your good faith relationship is by having a joint bank account. Do you have a joint bank account? And sometimes they tell us, oh, we don't mix our finances like that. And that's when I'm like, maybe it's a good idea for you to do that. And at that point in time, it's maybe a post-nup agreement is not a bad idea for this couple. So very, very neat and very good to know. Quick question for either of you. Should a prenup or a post-nup between a green card holder and an immigrant spouse be any different than one between a US citizen and an immigrant spouse? So does it matter what somebody's immigration status is when thinking about a prenup or a post-nup?
So we do ask our clients or potential consults as they come in what their immigration status is, because it does add a layer of discussion that we might want the parties to have on their own.
Mm-hmm.
But with a prenup or a postnup, we can pretty much put whatever in there that the parties want to agree to. Now, that doesn't mean that it's going to be enforceable by a court if the parties litigate the prenup or the postnup, but we like to think of it as, like Kara said earlier, this is a roadmap, and both of you should be on the same page. So hopefully we've discussed issues about financials, immigration, and all of that. So we can include in a prenup or a postnup what the parties would like done in the event of a divorce if their immigration status isn't where they want it to be yet. So for example, if one party is, sponsoring the other to obtain a green card, or, those types of things we can address in a prenup or a postnup. But again, whether or not it's going to be enforceable with the court is a whole nother discussion.
Interesting. I've never thought of it that way. Very good to know. Yeah, the enforceability of prenups and postnups is what my little understanding of them is that, yeah, you can write whatever you wanted it, but is it going to be enforced in court is the bigger question at hand.
Right. And a lot of times clients do ask us that question. And really the goal, right, of a prenup or a postnup is to avoid a nasty or messy divorce or separation in the future. So I will say the majority of prenups probably never get litigated as long as they're drafted by an attorney who knows what they're doing, and as long as both parties really are on the same page. The majority of them we don't see, right? We don't actually see them litigating them in court, because people are either just agreeing to it when they separate, or they've already had all the discussions and their relationship is, at the place where even if they do separate, they're still able to have those difficult discussions, even though the relationship is falling apart. So
it just sounds like it's good for your relationship, if anything. It's a good exercise.
It is definitely a good exercise.
Very.
Yes. Yeah.
So this question comes up a lot with my clients. Are prenups and postnups public record? Can they negatively impact an immigration case? You don't necessarily have to know the answer to this, but essentially that's the fear that, Anita, what if the immigration officer finds out that I have a prenup? Are they going to frown upon my marriage? So are they public record?
No, they are a confidential contract between two parties. The only time a prenup or a postnup is going to make it into the public record is if it's contested in a divorce. So at that point in time, that document would need to be presented to the court, because that's ultimately what they're fighting over. But without that, that's a confidential document between the two parties. It is not public record. It's not recorded anywhere. It's not filed with any courts. That is just between the parties.
So if I were to have a prenup, we draft it up and I just save it with my important records? Is that all?
Essentially, yeah.
Your spouse keeps a copy, and then the attorneys will also keep a copy. But we maintain it in our, confidential file. Nobody else ever sees it unless the client requests a copy of it in the future.
Awesome. And so you say attorneys. Does there have to be more than one attorney that's helping me with the prenup?
So the answer is yes and no.
Like most legal questions.
Exactly. So technically,
it depends.
Yeah, it depends.
Yes.
If spousal support is addressed, then both parties must be represented. That is what the law says.
Interesting.
If it's just a property division, prenup or a postnup, the parties do not have to be represented. But it is our policy that both sides be represented. And the reason being is you want this document to be enforceable. That is the goal, right? You want it to protect, and you want it so that it is as ironclad as it possibly can be without knowing what might potentially happen in the future. And so if you're going to go through the exercise of preparing it and you're paying for an attorney to prepare it, you want to make sure the other side can't come back in the future and say, well, I didn't really understand it because I didn't have an attorney telling me what all these things meant. And to avoid that, we do advise our clients to just, hire the attorney and make sure this is done right. Because if you're going to do it, you want it done right to avoid potentially having it invalidated in the future.
Interesting. Very cool. What else should immigrants or just anybody know when it comes to drawing up prenups and postnups?
So I would say full disclosure is absolutely necessary and part of a prenup. That includes disclosing all of your assets, all of your debts, your current income, past taxes. All of that absolutely has to be disclosed to the other person when you're drawing up a prenup. And we still do disclosures with a postnup as well, because sometimes that information hasn't been shared. And we do want to make sure that those disclosures are done. So when people do litigate prenups, inadequate disclosures is one of the grounds that they use. Because when you're dealing with, are we going to keep all of our accounts separate and all of our income separate throughout the marriage? Both sides have to know what they're giving up in order to actually agree with that in good faith. So, when people draft these prenups, and then I had a consult the other day who had no idea what her fiance was making. And she had me review this prenup and was getting married the next day. And I can't recommend that you sign that. Like, you don't know what you're signing. Right. These disclosures are not adequate. And, that's definitely grounds to invalidate it later.
So what do these disclosures look like? Is it a form that has to be done?
So the disclosures are going to vary depending on the attorney that does it. We err on the side of caution because we want our agreements to be enforceable. So we use the same disclosure process that we use in a divorce, with the idea that if the disclosure process we're using for the divorce is adequate for the divorce, which is also full disclosure, then it absolutely should be adequate for a prenup. Because there's no law necessarily, there's no forms specifically for disclosures for a prenup. But for our purposes, we use the same disclosures that we would use in a divorce to make sure that the disclosures are accurate and adequate, so that it's not going to be challenged later for someone to come back and say, well, I didn't know that he was making $500,000 a year and I was making 50, and I gave up my rights to have that be community property. Right. We want everyone to make educated decisions. So that is one thing. The disclosures are absolutely necessary. And then the other really big thing too, the question that comes up for us all the time is, how much is this going to cost me? Yeah. Right. That comes up for divorces, that comes up for prenups, always. How much is this going to cost me? And, the base answer for us is always, I don't know. We can't tell you how much this is going to cost you, because a lot of it depends on you. And the best way to keep the cost down is for the parties to be on the same page and talk about everything ahead of time, right? Before you go back and forth to the attorneys, talk about everything between yourselves ahead of time, so that when you both go back to the attorneys, it's not a constant back and forth. One person makes the changes in the prenup, sends it back. We check with our client, they say, okay, and we're done, right? If you want to keep it simple and cheap, that's how you do it. There's got to be that communication. And I mean, that goes back to our very first point about prenups, that this is a great exercise for couples because it forces you to communicate, right? You have to communicate about these hard issues to get it done. So Yeah, if you want to keep the cost down, that's how to do it. But it also really does help with the relationship to have those hard conversations.
That's the hard part, right? And I feel like a lot of people with prenups too, like I think Lydia, you mentioned it in the beginning. I feel like everybody is okay with doing prenups now, or maybe Kara was you, because everybody is getting married later and all of that. But I don't know how many years ago prenups were more so frowned upon, of like, oh, you're laying the bed for your divorce, you're just assuming you're going to get a divorce. But that's not the right way to think of it. The right way of thinking about it is it's essentially hiring like a therapist to help you talk through these difficult things that nobody wants to talk about, really.
Yeah, it's about educating yourself, right? About potential outcomes of what could happen if there was to be, a separation or a divorce. And then it's, putting into place protections that you want to avoid that. And I think another point is also, people are getting married later in life, but people are also more realistic about what marriage means, right? Divorce is not as taboo as it used to be. People are not stuck in loveless marriages like a lot of people used to be because they felt like they couldn't get out. Now it's, much more acceptable to, if you're not happy and if it can't work out, then why be unhappy for the rest of your life? Why not try to move on? And people do move on, and people sometimes get remarried, people sometimes stay single, but people do move on and live happy lives after divorce. So it's about being realistic about that could potentially happen, and then making sure that both of you understand what's going to happen if that does happen, and then being on the same page about how to divide things or how to characterize things.
Right, absolutely. So lesson learned today to all of our listeners: exercise. Exercise your relationship and your body too. Okay, let's keep going. I have a couple of more questions. So this is, again, it's more so immigration related as well. So do you guys know whether or not the prenup or the postnup would have any impact on the affidavit of support, which is immigration related? It's a contract that the petitioner, so the United States citizen spouse, would be entering into with the U.S. government, saying, if my spouse were to be getting public benefits of any sort, I, the U.S. citizen spouse, because I'm financially sponsoring them, I will make sure to pay back the government anything that my spouse takes from me, from the U.S. government. Do you know if prenups or postnups, can you contract out of that, or how does that work?
So you can't contract out of that, but I'm going to leave this to Kara because she dealt with this somewhat recently.
So the issue here is that, and there's somewhat recent case law on this a couple of years back, the affidavit of support will trump any spousal support waiver in a prenup. All right, so for a postnup, it doesn't matter because we can't deal with spousal support. But if they do a prenup and the immigrant spouse waives spousal support or limits it in such a way that it would be less than what's required under the affidavit of support, the affidavit of support is going to win. So they cannot completely say, I'm not going to support you at all in a divorce if they have signed this affidavit of support. And when it comes to divorce proceedings, if that immigrant spouse can't support themselves and they signed that waiver, that spousal support waiver in a prenup, that affidavit of support is going to kick in, and that citizen spouse is going to have to support them.
Very interesting. And one additional thing that, like, immigration wise, I could add, some people ask me, well, if I get a divorce and I'm no longer with this immigrant spouse that I petitioned, after divorce, does the affidavit of support obligation die along with my support? And with that, the answer is no. the affidavit of support, the I-864, will outlive a divorce. There's a very few things that will bring an end to that affidavit of support. One of those is death, or it's death or having 40 gainful quarters of employment, which, doing the math, which I personally don't like to do, that's why I went to law school. Doing that math is 10 years of gainful employment. So it goes on for a while, or if the immigrant becomes a United States citizen. So divorce won't do that trick. A prenup won't do that trick. So be mindful of that. And with affidavit of supports as well, I tell my clients too. Yeah, sure, it's cute and bubbly now, right? Your marriage is happy and you just got into it, but these are things that you genuinely do need to think about, because that goes on for a while. It's a serious obligation. It's a serious contract that you're signing and entering into with the United States government. So think about that. Okay, my next question is, should a prenup or a postnup be translated into the native language of each party?
Yes. So if one party is not proficient in English, which is the language that we use to draft our agreements, then it must be translated, not only just translated by a translator, but we use a court certified translator to make sure that if we ever had to litigate it, we can go to court and say, a court certified translator, we know this is an accurate translation, translated it, and then we have both parties sign both the English version and the translated version.
Interesting. And so how do you determine whether or not somebody is proficient in English?
So for us, if our client is the native English speaker and the other party is not, we gauge comfort level, right? We ask our client, do you think your fiance is proficient or not? And if there's any hesitation, then we will push for it to be translated. Because again, if you're going to do it, you want it to be as ironclad as possible.
Right.
And if the other party is not proficient in the language, that is grounds for setting aside or invalidating the prenuptial agreement. So if it's our client who is not proficient in English, we can gauge it, based on our conversations with our client. And I have had clients who, are native Mandarin speakers, who are fine. They're proficient with English if they read it because they have the time to process it, but they're not maybe proficient in just conversations. And so that, again, is something that I gauge with them and discuss with them comfort level wise. If they read it and they can basically regurgitate the information and it's clear to me that they understand it, we might not push for translation. But if it's clear that they don't understand or can't grasp all of the legal concepts, we will require that it be translated.
Interesting. So just to play it safe, the better thing to do is to do that translation. Very interesting. And
absolutely. And one thing also to note there is that that's definitely going to increase the cost.
Of course.
Having translations done, court certified translations of prenups, which are somewhat lengthy documents, it's not really cheap.
What is the difference of a court certified translator versus a regular translator?
So a court certified translator is somebody who's gone through additional training and can translate documents that are admitted to the court. It's basically somebody who's been certified and the court has approved them as a translator or an interpreter. Usually they also interpret for the court, but they'll have a separate certification for translation. And again, being, with the understanding of if this will be litigated in the future, we don't want somebody coming in and saying, well, your mom translated it. How do I know that she translated it accurately, right? We want to make sure that it's a neutral, somebody we hired that we know the court will admit, that evidence into court because we know that that person is certified by the court.
Interesting. And so does it have to be a family court? Does it have to be the family court in your state? Does any of that matter?
In terms
of the certification?
So I've only worked with court certified translators from California, but not necessarily restricted to like county boundaries. The last court certified translator I used was in, I think, LA, and we're in Northern California. So, I mean, it's still the state of California court system. So if they're certified by the California State Court, you know, San Diego, LA, it doesn't particularly matter so long as they are a court certified translator. Because like Lydia said, like, do you want your mom to translate this for you or your friend? You know, we want someone who is trained in translating the legal terms.
Right.
Because it is full of all of the legalese, and people need to be able to understand that in a language that is comfortable for them.
Very interesting. So enough prenup, postnup talk. Let me ask some, I guess, more grim questions about divorce, and switch over to that. What I guess overall, what should immigrants know about just the divorce process in the United States?
So one of the big questions that we get with immigrants is, depending on which state they're in, every state has different rules. So every state has different laws, and each county even has different rules. So if this is and a lot of immigrants who come may not, you know, they may not be staying here forever. And sometimes even if we go back to the prenup issue, you know, you may enter into a prenup here, but you may end up moving somewhere else. So we always make sure we explain to people about, if you do move, what does that look like in a prenup, but also in a divorce. If you're getting divorced in California versus if you're getting divorced in Texas, there are very different rules about how spousal support works, about how property division is, and even child support. In California, we have a guideline child support system. So that means that wherever you are in California, whether you live in Stockton or Fresno or Sacramento or San Francisco, you know, we use the same calculation, the same algorithm to calculate child support. So it's very important to consult with an attorney in the state or county in which you are residing before you proceed with divorce. And if you believe you will be moving within a short period of time, it makes sense to also consult with an attorney in that state and county to determine whether you file for divorce where you are right now, or whether you wait until after you move and meet the residency requirements there and file for divorce, because where you are could greatly affect the outcome of your divorce.
Okay, interesting. And if I'm moving, I don't have to get divorced twice, right? A divorce in California would be a divorce in Texas as well, right?
Correct. Yes.
Yes,
So as long
absolutely.
as valid divorce wherever you are, in whatever state you are, you can actually register that divorce judgment, your divorce decree, in whatever state you move to, especially if there are ongoing orders about custody visitation, child support, or spousal support.
Very interesting. Very good to know.
I'll even go a step further than that. You can register a judgment from a different country.
Correct.
In your current state. If there are ongoing orders.
Correct.
So, I mean, I previously had a client who was divorced in Haiti and then moved to the United States, and there were custody and support issues. And there's lots of jurisdiction issues, but long story short, the divorce judgment from Haiti was still valid in the US.
Mm-hmm.
Interesting. And it's just that getting it registered.
And that's another question we get a lot too from immigrants is, if I got married in, you know, Taiwan or China, you know, do I get divorced in the United States or do I get divorced there? And the answer is, you know, in a lot of these countries, you can go back and get divorced there. For the US, each state has its own residency requirements. So long as you meet the residency requirements and your marriage was valid wherever you got married, then you can get divorced here in the United States.
What is the residence requirement in California or in the Santa Clara County, just as an example, so people know?
Sure. So for Santa Clara County, you must be a resident of the state for 6 months and then a resident of the county for the past 3 months prior to filing.
And that's not just Santa Clara County. Those are the residency requirements for the state as a whole.
Okay. So I have to be living
so whatever
in the state.
Or at least
Yes, you have to be living in the state for 6 months, and then whatever county you're filing in, you have to be a resident of that county for 3 months. There is a workaround with that, though. If you haven't been a resident of the county for 3 months and you don't meet those requirements yet, you can always file for a legal separation, which those residency requirements are not required because you're not actually getting divorced. But then once the person meets those residency requirements, we amend the petition to make it for divorce rather than legal separation.
Interesting. So lots of creativity there to get what you need done. I love it. What happens if if an immigrant were to begin divorce proceedings before they receive their green card? What advice would you give somebody that walks into your door with that?
So we get that question quite a bit too. And generally, I defer to the immigration attorneys as to how it's going to affect their immigration case. The family court itself does not treat immigrant spouses any different from citizen spouses. They will still walk through the same custody visitation, child support, spousal support issues. But sometimes immigration status does come up, and we have seen, people file or people I threaten to deport the other spouse, and we've seen that a lot in domestic violence cases where one party might threaten to deport their other spouse or the spouse. But threats to deport could be viewed as domestic violence, and that might be an issue where we would file a restraining order against the other spouse and include in their orders that they specifically cannot threaten using the immigration status.
Oh,
So
wow. That's
this is where we work, hand in hand with the immigration attorney and make sure that what we're doing on the family law side isn't affecting the immigration case and vice versa.
Yeah, absolutely. It gets a little bit, it's not as tricky as it is stressful for the immigrant spouse. I can tell you that much. There are options if you find yourself in that situation where you're almost gonna either you're almost gonna get your green card, or you're going to have the conditions removed off of your green card, or whatever it may be. Consult with an immigration attorney to see what your options are, because there are options. Immigrant spouses are well protected in U.S. immigration, and just know to reach out to get the help and guidance from an immigration attorney, or ask your family law attorney if they can support you. And more often than not, we attorneys like to stay in our own lanes. I don't touch anything family law related, anything tax related. I always defer to my referral partners. And I know Lydia and Kara do the same as well. So just ask for help. I think that's what I always advise people, and that's what I say during these podcast recordings time and time again, or just even in webinars. So just get the help that you need from the professionals that work with this day in and day out. Anything else either one of you would like to add in or emphasize before we end today?
So I just want to reinforce, some of what we said. Prenups and postnups, they aren't for everybody. They're not always the right fit, but we're happy to talk people through their situation and see if it's something that they want to do. If it is something that you want to do, make sure you talk to your spouse or your fiance. That is the number one piece of advice I can give, is make sure you're on the same page, talk about those difficult issues, talk about your finances, be very transparent, because if you aren't, it's going to cost a lot, take a lot of time. And maybe if you aren't, disclosing everything through the prenup process, it could bite you in the butt in the end if you are getting a divorce and your prenup is set aside entirely because you weren't honest. So definitely make sure you are in good faith, being transparent and disclosing everything.
Awesome. Thank you. Kara, anything else that you want to add?
One other thing, if, and I mentioned this very briefly earlier, but not as specifically, if you own real property, or if you have a business or business interests and you are thinking about getting married, please talk to a family law attorney to understand how that is going to be affected with your marriage and whether or not you want to do a prenup. Those two items are the number one thing that we always tell people. You need to talk to someone and understand how California law treats these two items during a marriage to know whether or not you want a prenup, because those are issues that we can deal with in a prenup or in a postnup. But if you don't talk to a family law attorney, you're not going to know how that actually affects you. So if you have real property, if you have a business, please just talk to someone before you jump into that marriage. Just so that you're educated. You can make that educated decision about how you want to run your finances and your life.
Right. So major takeaway for everybody: ask questions, educate yourself, and prenups are not taboo. So don't psych yourself out about them. Many thanks, Karen and Lydia. Thank you so much for sharing your insights with us today. And thank you for all of our listeners for joining me today for this episode of Immigration Law for Tech Startups. Sophie will return next week, I promise. Be sure to check out the resources in the show notes, including how to reach out to Karen and Lydia. Please feel free to share this podcast episode with anybody you think may benefit from today's discussion. You can find Immigration Law for Tech Startups on Apple Podcasts, Spotify, Google Podcasts, or your favorite platform. Please rate, review, and subscribe. We appreciate your feedback so much. To stay tuned and updated and never miss another episode, subscribe to our mailing list that you can find in the show notes as well. Thank you all so much for listening, and I look forward to talking with you all again.